and they disappear behind the wall into this other concentrate making room where it's secret. And they ask them and say, well, what are these pipes going behind these walls? Is that you?
Evidence. We are so far.
That isn't evidence, Your Honor. That's in the Southern Nevada Health
District. It's not
District.
part of this motion at all.
Excuse me.
I'm making an objection,
gentlemen,
and then you can
objections, Mr. Odou.
All rise. Department 16 is now in session. I'll continue with presiding.
Are they still talking?
No, Your Honor. Please be seated.
We're on the record, Your Honor.
All right, good morning, and this way, what are appearances for the record?
Will Kemp, Eric Pepperman, and Theodore Parker.
Good morning, Your Honor. Jim Neale and Mr. David Spurlock for UNFI.
Good morning, Your Honor. Joel Odou on behalf of Real Water Inc. and IndianLifestyles.com.
Morning, Honor. Scott Rasmussen on behalf of Hanna Instruments.
Morning, Your Honor. Jim Kavanaugh, third-party defendant, Real Water Tennessee, LLC.
All right.
Good morning, Your Honor. Rob Robbins for Milwaukee Instruments.
And Mr. Robbins, good morning to you. Okay, I think that covers all appearances, right? It's my recollection, Mr. Parker, you had before, is that correct, sir?
That is correct, Your Honor.
Okay.
And I appreciate the court's indulgence for a quick second here. Your Honor, when we left off yesterday, we had engaged the court, I think every attorney here, a discussion regarding what a plaintiff in this case could potentially provide the court in terms of the concentration of hydrazine within the concentrate of real water. And the court pointed out some items that are very similar to some of the issues raised in some of the other cases we discussed at length. But it brought to mind, and I wanted to start with this, it brought to mind the motion, defendant's motion. And if you could, Chris, can you go to defendant's motion, MIL number 19, page 10 of 19. I'm sorry, go to page 8 of 19 first. So, paragraph number 7, Your Honor. And again, these numbered paragraphs are being provided to support the position by UNFW that Dr. Hudson can explain certain facts, and as a result should not be allowed to testify. So paragraph 7 says, he, being Dr. Hudson, concedes that the concentrate in any given bottle of real water may have varied significantly. The Honor probably spent 20 minutes yesterday asking and inviting commentary from all the lawyers in the room who would be in the best position to have tested the hydrazine level in the real water retail bottles or the 5-gallon jugs prior to dissemination to the public. And the question was insightful, and I think in terms of the plaintiffs, rhetorical, because certainly the plaintiffs were not in a position to test the real water bottles or jugs before they were sold to the public. So then that leaves real water. Perhaps it also leaves UNFW as a distributor, because they were providing the real water bottles. They had the ability to use a third-party testing company, but certainly rules out the plaintiff. And you can see by this brief that UNFW, selfishly of course, because of the retail bottles consumed by Mr. Haley and Mr. Belsky are an issue for UNFW, uses this fact against Dr. Hudson. Your Honor, this is the ultimate, and I'll use Mr. Pepperman's often used analogy, this is the ultimate straw man defense. Defendants know quite well, and the court pointed out yesterday, that the plaintiffs would have never been in a position to barge into the real water facility and begin testing their water for hydrazine or any other toxic substance. And Mr. Odou conceded yesterday it was not done. And then the court said, so what am I to do? What am I to do even if it was innocently created?
Well, and I think it's important to point out, and I was thinking about that because I understand it was inadvertently produced. The hydrazine wasn't anticipated as part of the production process. It was a byproduct, and I forget the exact term of art I used yesterday, and I guess the record would reflect that. Let me look at my notes if I wrote it down. But it was an unanticipated or something like that byproduct of the process. But, and just as important too, I circled back, but does it really matter? Because under strict products liability, the conduct of the parties isn't an issue. The sole issue would be this: is it a defective product and reasonably dangerous pursuant to the restatement of torts?
That's right.
Right?
So whether it's innocent byproduct, because no one at this point believes, or there's no evidence to suggest, that someone at Real Water took a 5-gallon jug of hydrazine and poured it into the concentrate. There's no evidence of that. So let's give Real Water, for the purposes of this discussion, the benefit of the doubt, and say it was an innocent byproduct of the electrolysis process utilizing the titanium tubes that resulted in the creation of hydrazine in the concentrate. That's what the evidence suggests. But it also, and
Yeah, I think I called it unintended consequences yesterday.
absolutely, Your Honor, and we can certainly, I think the evidence can certainly support that, the court's description. And just to address anecdotally something that Mr. Rasmussen said yesterday, no one is claiming that the ORC meter tests for hydrazine. But when the ORC meter is unreliable and results in Mr. Casey Aiken adding concentrate, increasing the quantity of concentrate, it results, unfortunately, in more hydrazine as a consequence of the concentrate being placed in 5-gallon jugs and retail bottles. And that's why Milwaukee and Hanna are here. In addition, of course, to evidence that supports that they knew that their ORC meter was being used by water bottling companies. to create alkaline water. So, Your Honor, Mr. Neale points this out in paragraph 7. And he further points out the quotation here, maybe each of those bottles had a high concentrate of hydrazine in them. And the court again pointed out to the defense, the water has been consumed. There's no way of testing the water that has been consumed. It's not like half a bottle of the bottle that was being consumed by Mr. Belsky or Mr. Haley is still available to test. What we do know is the degradation that everyone agrees to of hydrazine within the concentrate demonstrates for every hydrazine test performed on concentrate or retail water bottles that it was present in varying degrees. That circumstantial evidence points to all bottles had hydrazine in them, because the defense can't point to a single bottle that did not have hydrazine in it. It's simply there's no evidence to support. The other missing component for the defense is there are no other toxins identified in the water other than hydrazine. Your Honor, if for some reason I went home and I found what appeared to be a snake bite on my leg, and I was trying to consider analogies last night as I was preparing for today's hearing, Your Honor. And then there was a small snippet of one of the cameras in this courtroom showing a snake, just the end of a rattlesnake, slithering out of this courtroom. The question would be from the defense, well, how do we know that that snake bit Mr. Parker? And if Mr. Parker went to the hospital, how do we know that that snake had enough venom to cause Mr. Parker to have to go to the hospital? And then the question would be, well, how do we know that there were no other snakes that came into this courtroom and bit Mr. Parker? Perhaps it wasn't the snake that Mr. Rasmussen had in his bag, as opposed to the snake that Mr. Odou had in his bag. Who knows what snake bit Mr. Parker? Was it a young snake? Was it an old snake? The point in the comparison, Your Honor, is there's nothing else in this courtroom that could have caused the bite mark. And just like that example, there is no other item identified in this case that could have caused the injuries, the acute liver injuries suffered by the plaintiffs. Nothing. It's not turmeric. It's not kratom. There's no other toxic ingredient or byproduct found other than hydrazine. And the defendants would have the plaintiffs prove to you through having the bottles available, which we don't, the bottles were consumed, have test results which were not taken by the defendants because they simply weren't testing for it, or explain the horrible, horrible QA and QC information that we've gotten from the Southern Nevada Health District, the FDA, the CDC, and Mr. Odou's own expert, Mr. Goldsmith. So paragraph 8, UNF says, the more important variable he maintains is the minimum quantity necessary to cause a liver injury, which is also unknown, arguing that even if the hydrazine concentration in the water were low, it still might be enough to cause a liver injury. What we do know, given the motion that the court has granted earlier, which was virtually unopposed by UNFW, related to Mr. Belsky and Mr. Haley's medical records, is we do have acute liver injury in both Belsky and Haley. So we know the injury. And we know the only hepatic toxic substance that they both consumed, was hydrazine contained in real water retail bottles. For Belsky, retail water bottles and 5-gallon jugs. But we also know that Belsky's mother and sister consuming real water, Ms. Belsky said she consumed water out of the bottles, retail bottles, fell ill with symptoms similar to Mr. Belsky. Your Honor, if we go to page 10 and 19, 10 of 19, paragraph 17 and 18. Chris, thank you. Says, instead of determining that Mr. Haley and Mr. Belsky ingested real water containing hydrazine at sufficient quantities close enough in time to their symptom onset to fall with a plausible latency period for hydrazine. I think you meant to fall within a plausible latency period for hydrazine. Dr. Hudson instead concludes that their hepatitis had to be caused by hydrazine because they had hepatitis after claiming to consume real water. Well, that's not what you've heard already, Your Honor. What you've heard is Lori Kingston and Sarah Sandstrom have both testified that Mr. Haley consumed real water within the latency period, within the spring and summer of 2019, well within 120 days or 20 weeks. Mr. Neale yesterday said, or 2 days ago, said that, oh no, the last time there was documented proof was perhaps in 2018. He neglected to tell you about Ms. Sandstrom's testimony or Ms. Kingstrom's testimony. And in part, that deposition was blocked, given what you already heard yesterday, Your Honor. But the point is, Dr. Hudson was aware of that testimony. He discussed it in his deposition. It's there in black and white for the court to compare. So to the extent that Mr. Neale or anyone else would like to cross-examine Dr. Hudson on that point, again, it goes to the weight, not to the admissibility. Paragraph 18 says, but because hepatitis has so many potential causes, properly determining causing, again, this was poorly prepared, causing requires, thinks causation requires a physician to rule out potential alternative causes. Your Honor, I went through testimony yesterday with Dr. Hudson before this court where he specifically addressed alternative causes. He specifically addressed in terms of Haley turmeric, in terms of Belsky kratom, and ruled them out because in his opinion, given a long history of use of both those items, that they're not hepatic toxic. In fact, he found them to be hepatic protective, antioxidants. He went down a list, and we'll get to that shortly. But my point is, these paragraphs and the ones I've already shown you between yesterday and this morning are all disproved by the testimony of Dr. Hudson, testimony of Mr. Haley, testimony of Mr. Belsky, testimony of Maria Belsky, testimony of Lori Kingston, and the testimony of Sarah Sandstrom. 3 current employees of Whole Foods have provided testimony opposite to what UNFW is arguing right now and what Whole Foods attorney is arguing right now. Whole Foods, Ms. Sandstrom's own attorney has disproved what Ms. Sandstrom's attorney has said to this court. So I don't know if it's the UNFW's intention to try to impeach their own employee, or in this case, their own client on the stand, but their client, Whole Foods attorney, representing the Sandstrom, has to concede that in her deposition, she indicated that Mr. Haley consumed real water in the spring and summer leading up to his acute liver injury. If you go to page 15 of of UNFW's motion, please. And this is beginning at line 19. That's good. UNF says, if nobody knows how much real water must be consumed to be hepatotoxic, then any causation opinion is based assumes, again, it's kind of awkwardly drafted, that so long as one consumed real water and later developed non-viral hepatitis, that the quantity of the real water consumed was sufficient and must therefore have caused the condition, despite what Dr. Hudson concedes are hundreds and hundreds and hundreds of other potential causes. Your Honor, that's what Mr. Kemp has said many times. You cannot come to court, given the Williams case, and say there was 100 things out there that could have caused it if you don't have any reliable evidence to support that argument. And that's not what Dr. Hudson does. He tells us in his opinions and during his deposition that the cause is hydrazine within real water. That's it. And he's considered the other causation arguments made by UNFW's expert, Dr. Doris. Can we go to reply now, Chris? UNFW's reply, John, starting at page 3. The bullet points at the bottom, starting at line 26. This is UNFW's believed summation of why this motion should be granted. And you'll notice through these bullet points how UNFW uses the lack of quality control, the lack of testing, the lack of availability of real water to support trying to limit what testimony Dr. Hudson can provide to this jury.
Well, I don't mind saying it. I mean, I don't want to circle back, but that's why I asked the question I asked you yesterday, the day before, what I do with this, because these are just observations. Number one, we have I think we have to focus on real water's production processes, and specifically focusing on how they introduced potentially hydrazine. And I understand it was an unintended consequence, but nonetheless, that's not a defense. We can all agree to that. But what the defense is asking or attempting to do, based upon my impression, would be this. It would be saying, look, Judge, yes, it was produced by real water. Yes, it was unintended. It was part of our processes, however unique it might be. And yes, it dissipates. Yes, potentially people got sick. But because the experts, based upon the fact that over time, there's degradation in the amount of the real water, and so it doesn't make testing current bottles or bottles within the test period necessarily germane to determining what the toxicity levels, if any, were at the time of production.
That's right.
That's kind of a big deal, right?
Absolutely.
So how is that, and so their failures are being used as some sort of obstacle to plaintiff's proof in this case.
Exactly. That's exactly right, Sean.
I mean, that's kind of how I see it, right?
No.
It would be one thing if hypothetically there was no degradation, the expert failed to test what would be appropriate to lay the appropriate foundation under Nevada law, right? And that could be hallmark and the appropriate testing. But my point is this: what testing could this man have done? Or anybody could have done as far as the content of hydrazine in the bottles? Doesn't matter whether it's retail, I understand it. And, I don't mind saying this too. I'm glad I haven't issued decisions yet, because, each time I go back, I'm working on them again because I know more facts.
That's right.
I'm clear on the issues in this case.
That's right.
And so In fact, this morning I was going over some more minute orders that I had done before, and I'm tweaking them. I don't mind telling you that. And because I know more about the case now. And so what do I do? And that's why I asked the rhetorical question, what do I do? Right? Is that an issue, Judge? You should ignore that. Or is it an issue? So on and so on.
And Your Honor, I will tell you, your questions are so on point, and I'm bringing up, because of the comments and the colloquy we had yesterday, I'm bringing up points within this motion and reply that affect those considerations. Because Your Honor made it real clear, and I'm assuming that the defense picked up on it as well. If you cannot hold the plaintiff responsible for not testing prior to distribution of the real water, then who do you hold responsible for that product? And it's not a negligence claim.
In a strict products liability.
That's right.
Right? And I understand it was an unintended consequence. Maybe there's a problem with the processes that were used. I don't know. But at the end of the day, does it matter if it's an effective product? Because the focus and thrust is on the product. And I started that from day one as far as this case is concerned. Yes, I thought I had to get up to speed on what did I call the term? Similar events, right? And that's what I call it. I know in Krause, the court said similar accidents, but these are events, these aren't accidents.
That's right.
I get that. And probably in a generic term, whether it's a manufacturing design case and or a production issue.
Right.
I think it probably should be similar events because that's more generic.
Yes, agreed, Your Honor. And the reason, and this is a throwback to my analogy, the reason why I suggested two snakes in my analogy is because from UNFW's perspective pertaining to Mr. Belsky, it's the 5-gallon jug, in his opinion, versus the real water retail bottles. And so I put a snake in Mr. Rasmussen's bag and one in Mr. Odou's bag because they both have venom. They're both rattlesnakes. How do you determine which one caused the problem? That was a line of questioning by Mr. Neale to Dr. Hudson. And Dr. Hudson says they both have the same concentrate. And he was drinking and consuming both at the same time. He had bottles in his refrigerator that he was consuming, as well as other members of his family when they came to visit, when he was in the hospital. And he had the 5-gallon jug. It is impossible, but that impossibility can't be held against the plaintiff because the plaintiff didn't put that product in the stream of commerce. The plaintiff had nothing to do with testing. Real Water should have tested, if anyone. UNFW should have tested if they had a concern in terms of quality control and quality assurance of the Real Water facilities, be it DI or Henderson. And it wasn't done. And as a result, an adulterated product based upon Nevada statutes was introduced into stream of commerce that ended up at Whole Foods and our clients consumed it. So when we go to page 3 of 8, the first bullet point under UNFW's second major heading in its reply says, even the approximate hydrazine concentration present in any bottle of retail water. How could Dr. Hudson ever know that? It is impossible for him to know. Because they being the defendants in this case, did not test it. They didn't know what it was. Sorry about that, Scott. I felt a little backlash from you on that one. This does not necessarily implicate Scott Rasmussen's client on this particular point.
Okay.
Fair enough?
Yeah.
All right. The next bullet point says, the more important minimum quantity of hydrazine necessary to cause a liver injury. Well, plaintiffs have already identified a toxicologist, Your Honor, and a water chemist, Dr. Naj and Dr. Kosnak, who've issued opinions regarding the toxicity of hydrazine. And the opinion about the Hudson is that the hydrazine in the real water caused these injuries. The consumption of real water caused these injuries. The third bullet point says, whether the concentrations of hydrazine present in any retail water at the time of consumption were hepatotoxic. Again, Your Honor.
I mean, here's another thing though I think about, I don't mind saying it because I think that it's important for the record. I was saying to myself, and what do we know about the vetting of the production process?
What we do know is that there was no QC and new QA.
Okay.
Other than that, we just know Dr. Marlowe.
No, I'm just going back to
Mr.
a lot of these production processes I would anticipate are vetted. And what I mean by that is, and we kind of know this in a general sense, I'm just being very generic, but reverse osmosis has been vetted, right? As far as water production. But what was going on in real water, had that process been vetted on any level that, this is something that might be okay? And the reason why I bring it up is this, it seems to me that potentially if it was vetted, maybe if it was vetted, and you look at the results, you might know hydrazine was a potential byproduct.
Very, very good point. To my knowledge.
Well, but see, you can shake your head, but I'm gonna tell you this. I'm asking a question. Why wouldn't we know that? If the process was vetted.
I think they're shaking their head negatively because it wasn't vetted. I think Marlowe came up with this on the fly and
But that's not how it's vetted. I mean, someone can create it, right? It's kind of like this, and this is really kind of an important point. It's when you look at, production of products for human consumption, I would anticipate there's many ways to vet products as far as toxicity, processes, and those types of things. So he might have come up with the process, but was that process accepted by other water manufacturers as a production process for this type of alkaline? You see where I'm going?
I do.
I see exactly where you're going, Your Honor. It's a very astute observation, and especially in this case, because what the problem was here was in the concentrate making process, which was done behind closed doors in a secret room by essentially one person, Blaine Jones, to the exclusion of anyone else in the company. Even if they had a qualified QA or QP person, they weren't allowed in the concentrate making room when this was being done. And in any inspections and audits, they hid that process behind closed doors. And this is all laid out in the when the FDA investigation came in. At first, when they came in, they go into the Henderson facility and they don't show them the concentrate making room. They don't even let them know that they have this other room where water or concentrate manufacturing is going on. And it took the FDA inspectors and the Southern Nevada Health District inspectors to look around this building, and they see these pipes coming in from the water production equipment, and they disappear behind the wall into this other concentrate making room where it's secret. And they ask them and say, well, what are these pipes going behind these walls? Is that you? And the real water says, I don't know what that is. That's not us. They initially deny it. Eventually, that doesn't hold up, and they confess and say, oh, this is the concentrate making room. But it shows the lengths that this company was going to hide the concentrate making process where this is the problem. And so your observation...
That's not evidence. We are so far...
That isn't evidence, Your Honor. That's in the Southern Nevada Health District.
It's not part of this motion at all.
Excuse me.
I'm making an objection, and then you can...
Objections stood. Mr. Odou, and here's, I guess here would be my follow-up question to that. Was there other water manufacturers who used the same process?
Yes. And again, we are
Where's
so
that
far
in it?
removed from the topic of this motion. We are now talking about other issues and other facts in this case, and that's my objection. I thought Mr. Parker left because we've gone on to a different topic.
But here's my point, and you can answer this question for me, because I'm looking at it from this perspective, because at the end of the day, the processes that were in place are at issue.
Yeah, then we should have admissible evidence on that, Your Honor. It's not part of this motion. It wasn't introduced in the 10-line motion for summary judgment. We should have admissible evidence on this.
This is a motion to exclude testing.
This is a motion under Hallmark challenging a specific expert, and that's it. And we are way down the road on some other issue, and That issue does not have evidence before this court.
Okay, but I have questions.
Your Honor, let me address that, let me address that, because I'm not sure, Mr.
I thought Mr. Pepperman wanted to finish, but whatever.
I am positive, 100% positive, that Mr. Odou is not trying to be insulting or cut off the court's inquiry, because that would be inappropriate. Because the court has the discretion and the right, the ultimate right, to ask whatever question it deems necessary. And so Mr. Pepperman was simply responding to the court's inquiry. And Mr. Odou can do the same after Mr. Pepperman, or I don't care the order, but the court asked the question and it deserves a response. And so that's what Mr. Pepperman was doing.
Because I don't mind saying this, I mean, I understand the homework, I understand the assistance requirement, I get that. But these motions are far more nuanced than that. And what I mean by that is this. I'll make it a real simple issue. Say you got an expert in slip and fall case that didn't conduct a coefficient of friction of the walkway surface. Okay. Gone, right? But what happens if the walkway surface was destroyed? That's a different issue. And that's all I'm really kind of focusing on right here. Because when I read the points and authorities, it was implicit in there, but what jumped off the page was essentially this. That yes, I understand what an expert would do from a historical perspective when it comes to the assistance requirement. And I don't mind saying, I've seen experts in almost any kind of case you can think of, right? Whether it's orthopedic or spinal or coefficient of friction or product design or framing or soils and we can go down the list, right? And sometimes, I mean, most of the time, they have the capabilities within the appropriate time period to go out and do the appropriate testing. We know that. I mean, I remember I had a soils case, we can talk about that. And who was it? Lenny's partner.
Oh, Adam Springle.
Mr. Springle tried that case and defended it, and he did a pretty good job, I thought. But anyway, I understood soils and stuff, but my point is, certain things have to happen, right? But what happens when, and not at the fault of anyone, where just the circumstances change, where it's basically impossible to conduct those types of threshold analysis that you normally would do.
And the expert puts it in his report. That's what happens. The expert says, this evidence was lost, this evidence was destroyed.
Right.
And then there's a motion before the court, and there's evidence rather than an argument of counsel. That's the only point I was trying to make.
Okay, but I get that.
We are so far.
But did I come back, but see, my questions are more geared to the issue at point, because there's a motion to exclude his testimony. And it's based upon the fact that he couldn't determine the toxicity levels of the retail and/or 5-gallon jugs at the time of consumption because of dissipation. And we know this because what testing was done as it relates to those issues? Zero, you know? And that's why I was very,
That's a choice, Your Honor.
what do you mean a choice?
You could, there's plenty of water that's sitting still out there at that facility if you wanted to test it. You could then confirm that it's all dissipated. That was never done.
Well, but,
That's not.
well, here's my point. And I can, maybe there's one agreement here with all the parties that it dissipates, right? Hydrazine in the water. I thought that was not an issue,
That's right.
right?
I would concur that, yeah, yes.
And then-
depends. There's so many variables in chemistry that
I understand, but it dissipates over time. How about that?
I would say it can.
they can, that's a better, yeah.
Okay.
That's, yeah. In the concentrate area, its opportunities to dissipate is different than once it is introduced into the real water product.
Right.
So in other words, the dissipation rate, Your Honor, if I can just add this now to your facts of things we're trying to educate the court a little bit, is going to be different in a particular form that it is, okay?
I understand.
Different things do different things. In chemicals, and in this case, what you were asked is, had other bottling companies done this? The adding of salts, potassium hydrochloride or magnesium chloride or potassium chloride, those salts, those minerals that those are added into almost all the waters that we drink and everything that was there.
But that
They're not
wasn't
doing anything different than anyone else.
that wasn't really my question.
Right.
Because I'm talking about the processes utilized with the titanium tubes and those.
Certainly that was, the titanium tubes are absolutely unique, I believe, to real water.
Right? I mean, that's kind of, and that's why when I talk about processes, I wasn't limited to adding salts or
Right.
some other generally accepted.
Fair enough. Your correction of me is good, yes. The titanium part of this thing is absolutely unique as far as I've ever seen, or, you know, obviously as part of my defense requirements to defend my client.
Oh, absolutely.
I have to go out and say, okay, is this routinely done? My client knows nothing of this. So I have to go out and talk to Pepsi Cola and Coca-Cola and all these other, Fiji water. Luckily, there's a couple of bottlers out of Japan that I was able to talk to. They've never seen that titanium stuff before, okay?
And that's kind of my point.
Exactly. We, full circle. That's the judge's point. You got this unique process as
Well,
described. by
part of a
Mr.
process.
Listen, I'm just gonna accept what you said in the last couple of seconds.
But I
Unique
mean, but we
use of
can't.
the titanium.
Yes, that's what I said.
Okay.
But here's my point on that. We can't just cut and parcel part of the process. Either, it's like being pregnant. You go in between, either you're pregnant or you're not. And my point is, if they injected titanium tubing and utilized in a certain way, that's part of their process. That's part of apparently what made real water unique potentially. I don't know. But that's something that Fuji doesn't do. That's something that Aquafina doesn't do. That's something that, and I don't know much about this. Dasani, but I'm going into the more particularized, oxidized, or whatever you call these specialty waters. It's probably the best thing I can say it. That's nothing that anyone else does in that arena, right?
Yeah, I've never seen the titanium used.
Okay.
And no one else uses a composite hull to go down and visit the Titanic. The point is,
It's true.
just don't. And they won't anymore for a while, I assure you.
Another unique process.
Very unique process. And using the Atari controller, also a unique process. The point is, and I'm dating myself by saying Atari, but the point is, Your Honor, when you ask the straightforward question, the rifle at the target question, was this process vetted? I have not heard an affirmative response by anyone from the defense, not Real Water, not UNFW, not Hanna. And if Mr. Robbins wants to chime in, certainly, if he knows, and that's great. But what we have heard is what Mr. Pepperman said about what was found through the Southern Nevada Health District investigation. And so this unique process that uniquely developed, perhaps unwittingly, hydrazine has resulted in this. And using the courts.
Well, that's why I call it a unforeseen or unintended consequence.
That's
why
right.
I wanted to be fair on that.
That's right. And I think that's a very benign way of describing it. And, Your Honor, looking at a soils case, the benefit of a soils case is that an expert, a geologist, can go out during the litigation and test the soil if the soil is still there. That happens all the time. Me and Mr. Odou, Mr. Rasmussen, we've been in many cases, more than we care to remember, dealing with soils issues, be it North Las Vegas that has expansive clay materials, or Henderson that has soils. We are very familiar.
Really, that's so basic. That's what happened in the Xena case. The TV was destroyed. I mean, we know.
That's right.
I mean, it's
Very basic. And so to now blame the plaintiffs with the inability to test the water consumed by his clients, because there was no testing done beforehand, which you would think, given what the court just said, if you're using a unique new process, why wouldn't you test to make sure that the product was safe for consumption? That's the logical extension of the question. So, Your Honor, going back to page 4 here, there's no way you can determine whether or not, other than by the evidence we already have, that hydrazine dissipates over time, that it was present when it was created, because it's present in every test that was taken thus far. The next bullet point, second bullet point from the top says, whether even the highest concentration of hydrazine found in testing retail real water would likely cause acute injury. Your Honor, it's a bootstrap type position. If no one tested in the beginning, how would you know at creation of the concentrate and the initial bottling if it was high enough to cause injury? Well, we do know, even after years or months of bottling, people were still getting sick. That's what we do know. The third bullet point says, how many bottles of retail real water Mr. Haley and Mr. Belsky consumed? Again, Your Honor, that gets back to the conversation we had yesterday in terms of the lack of Whole Foods purchase data on the cash side, certainly, and the inconsistency between what the Excel spreadsheets provide versus the testimony of the Whole Foods employees, in addition to the plaintiff and Ms. Belsky's, Maria Belsky's testimony. Next bullet point says, what hydrazine's latency period is. Well, Dr. Hudson already testified, 2 to 20 weeks. That's in this testimony. Next bullet point, when Mr. Haley and Mr. Belsky consumed the real water relative to the latency period. Again, Your Honor, goes back to the Excel spreadsheet, the inconsistency between the spreadsheet and the testimony of Lori Kingston, Sarah Sandstrom, Mr. Belsky, Maria Belsky, Mr. Haley, and their depositions and fact sheets. And then the final bullet point says, why, if the supposed presence of hydrazine is a common defect in millions of bottles of retail water sold nationwide prior to 2021, public health authorities were unable to find a single case of acute hepatitis anywhere. I thought that Mr. Kemp did a wonderful job at explaining the MMWR report and what that really means when you look at the spikes in 2018, 19, and 20. And although no one had a suspicion, because no one thought that anyone would include rocket fuel in a consumable bottle of water, it finally came to light.
There's a reason why I ask, I just don't know the answers to these, and this is why I ask questions regarding vetting, maybe that's an inappropriate term, but it seems to me that potentially if the introduction of the titanium tubes being part of the processes was studied, maybe there could be a finding that hydrogen might be part of that process. That's all, nothing more, nothing less. That's why I asked that question. But if it hasn't been, and this hasn't been, and like I said before, unintended consequences, I was trying to be very benign as far as that's concerned. Potential, you know.
Of course, Your Honor. And, Your Honor, I wanted to go back to what the Vahina case. And the Vahina case is not just a case regarding sanctions appropriate for discovery abuses. It also reiterates what the court said about how we treat, how our Nevada Supreme Court treats items where we have case law and sufficient precedent as opposed to looking at the federal cases. This is Vahina number one, not number one, the first Vahina. The second Vahina, the rehearing said Vahina number one. But this is the actual original decision, the 25-page decision. And it says here, on page 8 of 25, Your Honor. And this is where the defense was critical of the decision of the district court, saying that the district court should have held an evidentiary hearing because the defense wanted an evidentiary hearing in response to the district court striking its answer. And the Nevada Supreme Court said, no, the district court was correct in striking the answer, ultimately reconsidering the striking of the answer and striking their liability defenses and only allowing them to argue damages. And that's what the Supreme Court affirmed. And it says here at the bottom of page 8, for the reasons we conclude that the same standard of review for striking all of the defendant's affirmative defenses applies when the district court strikes a defendant's answer as to liability only, but does not conclude the case as to damages, finding that an evidentiary hearing is not necessary if you're just striking the answer for purposes of liability. Then it says, our dissenting colleague, talking about Pickering, suggests we adopt a standard of review for discovery sanctions based on a parallel line of federal authority. And this is what I thought was very important to this motion, Your Honor. We disagree because there's ample Nevada case authority regarding discovery sanctions. Also, and this is the most important part of this motion, also we have expressly rejected the adoption of federal authority that employs mechanical application of factors regarding qualifications of expert witnesses. And that conflicts with our state law, Higgs versus State, Your Honor. 126 Nevada, 2010 decision. And I raised that point, Your Honor, because
It precedes Hallmark.
Yeah.
I mean, I get it.
And I raised that point, Your Honor, because Hallmark says we don't follow dogma. Higgs versus State, we don't follow dogma. The original motion filed by UNFW cited a 11th Circuit case, a 5th Circuit case, a 4th Circuit case. It cited Hallmark, but it seemed to retreat to those other circuits' federal cases in an attempt to bolster its position. Your Honor, it's only Hallmark, it's only Williams. And you're intimately familiar with both of those cases. Now, if you could bring up the deposition of Dr. Hudson, Chris. And, Your Honor, when we left off yesterday, we were on page 118. No, Your Honor, we ended on page 118, line 20. 19, actually. Do you have the deposition, Your Honor, or are you looking using the screen?
No, I have.
Okay. Your Honor, this is where Dr. Hudson tells Mr. Neale that he's not guessing. This is no assumption. This is not supposition. I don't think we're guessing at all. I think it's the same concentrate, it's the same water, it's the same bottle, so it's got to be both. And this goes back to my analogy regarding the two snakes that Mr. Odou and Mr. Rasmussen brought into the court that ultimately bit me. That's the point. He's telling and opining to a reasonable degree of medical probability that both bottles, be it the jugs or the retail bottles, contain hydrazine. He was consuming both. They're within the latency period, and they caused his acute liver injury. And he speaks specifically about this latency period further into this testimony. If you go to page 119, line 18, the point I'm trying to make is that trying to assign the causation to a 5-gallon jug versus the retail bottle is not possible. That's what I'm trying to say. Mr. Neale says, got it. And then in the response he says, but I'm saying that the causation is still there. It's still real water in both entities, and that's what caused the injury. This is no guess. He's not assuming. He's not equivocating. If you could go to
But I mean, the next question is this, it says, question, understood, but differentiating between them is impossible, that's correct. But why is that impossible?
Good question, and that's where we started today. It's impossible because there's no testing of the quantity of hydrazine in the 5-gallon jug versus the retail bottles performed by the defendants at the time of creation or bottling of these products. We know that the substance degrades over time. And we know that every test that was taken of the concentrate of the bottles resulted in a hydrazine finding. That's why. Now, had they tested for hydrazine when they should have, before they put the bottles out for consumption by the public, we would have a benchmark, a place to start. If their production process followed some kind of uniform approach, as opposed to, oh, the meter isn't right, we've got to add some more concentrate. If there's uniformity in this process, in terms of the amount of concentrate being added, we would know, because they would have tested, we would know what the concentrate, the level of hydrazine was at the time. Better yet, if they tested and found hydrazine, it should have never been put on the market. But we know that wasn't done. So that's what you're left. They create these straw man hurdles and then say, Judge, we didn't test, and there's no way for them to test at this late date, so they can't prove their case. It doesn't work. And so, in reading on, just to stay on the same page, Your Honor, 120, ultimately he says in line 14, the same water that goes into retail bottles goes into the 5-gallon jugs, so they're both at fault. And that's discouraging to UNFW because that means if you're in for a penny, you're in for a pound. Because now he's looped in to the 5-gallon jug consumption as well. And this again goes to Mr. Belsky, Plaintiff Belsky. If you go to page 121, lines 4, this addresses the latency period, Your Honor. It could be as long as 20 weeks, is what Dr. Hudson opines. The consumption by Haley, spring and summer of 2019, ultimately going to the hospital in August of 2019, is within 20 weeks. Maria Belsky and Mr. Belsky both testified under oath that he was consuming real water. It was by retail bottles. It was in his home, in his refrigerator, when he went to the hospital. Again, well within 20 weeks, within the latency period. And in fact, Your Honor, so you're not taking just my word for it, we go to fast forward to page 125. This is lines 16 through 19. This is Dr. Hudson. They all drank the 5-gallon water, I remember that. But I also thought that they drank the retail water as well, because there was water in the refrigerator, as I recall. Dr. Hudson isn't assuming, he's not guessing, he's not pulling facts out of the air. Now, I credit Mr. Neale on finding different ways to get to the same point with witnesses. And he did this with Dr. Hudson as well. Go to page 127, please. I'm sorry, before you do that, go to 126. Because this further kind of highlights the water bottles in the refrigerator, Your Honor. Lines 6 through 13. Says, here she's talking about Maria Belsky, Your Honor. You can see that from line 2. Maria Belsky being the mother of Plaintiff Belsky. Says, this is Maria Belsky, right? Question, right? That's mom, isn't it? Okay, with page 39 and 40. Says, okay, here she's talking about 20 bottles, retail bottles in the refrigerator. Question yet? Then Mr. Neale says, yes, sir. 40 bottles, but she filled them up. So I think she was saying there were 20 bottles, and once she drank them, then she filled them up with water from the 5-gallon container. But these were brand new bottles of real water in the refrigerator when he went to the hospital. Now we go to page 127, line 23. So then Mr. Neale changes gears. He says, let's talk about Haley and his specific consumption if we can. You're aware that he's an employee of Whole Foods. Dr. Hudson says, correct. And as an employee and has an employee discount card. Says yes, and uses that religiously. Now at this point, Mr. Neale, again, a very detailed person, throws in the description of religiously, the adjective. Actually, the adverb. And says, I don't know, the response from the witness is, I don't know that he uses it religiously or that that's all he uses. No, sir, I don't know that. And so at this point, Mr. Neale is trying to determine if he could get Dr. Hudson to agree that he did not use or consume real water during the latency period. And he's addressing what, of course, would be the exposure requirement of HOCA. Going to page 131, question, this is line 8, Chris. He says, and so we don't know whether Mr. Haley ever consumed any bottle with a dose of hydrazine in it that would be likely to cause an acute liver injury. His response, I would say that would be a false assumption, because if you assume that he didn't drink any bottles of real water with hydrazine in it, then why did he have a liver injury? He had a liver injury from real water. And this is after he'd done his alternative causation analysis, Sean. Because before yesterday, we'd spoken about his consideration of turmeric for Mr. Haley. We go to page 134, and this is where Mr. Neale goes back and forth with Dr. Hudson regarding consumption levels, starting at line 18. You believe that the purchase records are an accurate reflection of what he purchased and consumed on the job. The witness, no, sir. What I believe is the purchase records show what supplements he drank. Does the purchase record show everything? I don't know that, Mr. Neale. Why would it be different? I don't know. I just have to leave the possibility open that things could be missing because you know that purchase records can miss things. And he says, how do they miss things? His response, cash. If you pay cash for things, it doesn't show up on the purchase records. And this is something, Your Honor, we've talked about before. And then Mr. Neale says, if your employee ID card, he says, well, again, I don't work for Whole Foods, so I'm not aware of how their employee discount card works. Your Honor, Dr. Hudson, to a reasonable degree of medical probability, answered every question asked of him that any expert in his discipline, a hepatologist, could provide based on the fact that neither UNFW nor Real Water tested, vetted its products before it put it out for the public. They never tested for hydrazine, and yet they complain because our experts don't know what the hydrazine levels were at the time of creation of the bottle. They never tested to see how it was created. Our experts figured out that this process, the electrolysis process, in all likelihood generated the hydrazine.
And that's using the titanium tubing?
Absolutely. That's something they didn't do. They've not offered you an example or a reason behind, other than Mr. Goldsmith saying it was a filthy place. It was a dirty, nasty distribution center, office or facility, production facility, where you have a cashier acting as your quality control person, or a receptionist, I'm sorry, acting as your quality control person. And so that's an offer made by Real Water, and I'd love to see how that plays out in front of a jury. I'm sure a jury would love to hear that their own expert believes that they had a filthy, nasty, no quality control, no quality assurance protocol whatsoever that led to hydrazine-laced water being introduced to the public. I want to see how that defense plays out.
So I just want to make sure I'm clear as far as the current status of the evidence. A plaintiff has an expert witness that will opine that the process is in place as it relates to the titanium tubing resulted in the creation of hydrogen.
Dr. Najim, Your Honor. He's our water chemist.
Okay, the defense doesn't have an expert to contradict that.
Not that I'm aware of.
We will have our own chemist on there about that.
Wait, I'm sorry.
Well, they have Dr. Richardson who agrees with Dr. Nash.
Yeah, I don't know if there's any competing opinion to my
Well,
knowledge.
that's kind of, I guess,
And that's what you were getting at.
Yes,
We'll have our own chemist and we'll deal with that at an appropriate time. We're not in this.
but I understand, but he pretty much agrees. And I'm just focusing on
No,
this question.
he'll, on this thing, I think that is still open for discussion.
I'm sorry, Your Honor, if I could, I'd like the court's question. I'd love to have an answer to this.
First of all, it's a she. Dr. Richardson is a she. And she is the one that cited Dr. Nash as the authority and said, I think Dr. Nash's explanation is, I can't remember her exact word, logical, something like that. So she basically agrees with him on that point.
If Mr. Rasmussen is saying something different, I have not seen a report that provides a different explanation of how hydrazine was created.
We'll have Mr. Babcock available for discussion at some other point, but this is not our motion.
No, I understand. All I'm trying to get is the plan. That's
Okay.
right.
That's
See if that
Dr.
was.
Babcock's not the chemist though.
He is actually a chemist, yes, PhD chemist.
The toxicologist is Dr. Richardson, and if need be, after his break, we'll bring Dr. Richardson's testimony up.
So, what we do know is that, at this point at least, Real Water has not identified a witness that says it was something other than this electrolysis process that created the hydrazine. I think that's a fair statement, Joe. And so, Your Honor, page 137 of Dr. Hudson's testimony. And this is in response to Mr. Neale, and he's saying, because we only have 6 hospitals, their representatives, it should correlate linearly. So I'm going to read the response and bring more clarity to the remark or question by Mr. Neale. Well, I don't know that. I don't know because you have multiple different things that can happen, so you're picking turmeric. But we don't know that. And if you look at the representative and say, well, there are only 11 reported cases over what 12 or 13 year period, that means it's a very unlikely cause, particularly when you look back at the physiology of turmeric, has been shown to be heteropatic protective, in fact, and anti-neoplastic, anti-metabolic, and antioxidant. He's pointing out all of the things that turmeric has been known, the beneficial effects of turmeric, what it's known for, versus the unlikely chance that turmeric could ever be the cause of Mr. Haley's acute liver failure, Your Honor. And then, if you could go to page 172. And at the end, towards the end of his deposition, I think he brings everything clear on how much research he's done related to turmeric and why he believes, again, hydrazine is the cause. Starting at line 12, Your Honor. Dr. Hudson says, it doesn't matter to me because I believe that Real Water with hydrazine is in it is the culprit for causing his liver injury. I think that's what makes the most sense. You take a substance like hydrazine that has no beneficial effects and compare it against something like turmeric that has been shown in both animal studies, monkeys, rats, that it does have protective effects. So you're going to pick the substance that is most likely cause of liver injury, and that certainly is hydrazine. And that was his opinion in relationship to turmeric and as well as to kratom. And so, Your Honor, I don't believe that there's anything that's been offered by the defendants in its motion or its reply that has not been disproven by the testimony of Mr. Hudson, Dr. Hudson, I'm sorry, Ms. Sandstrom, Ms. Kingston, Mr. Belsky, Mr. Haley, Maria Belsky, the testing that was done by the FDA, the testing done by UNFW's routine laboratory, Eurofins, all proves the same points, Your Honor. The water had hydrazine in it. It was sufficient enough based upon our experts, Dr. Najim and Dr. Cosnet, to cause liver injury, and in fact, these plaintiffs all suffered acute liver injury. Given what Mr. Neale said at the beginning of his presentation, that they're not questioning the credentials, the experience, the education of Dr. Hudson, and given the amount of information Dr. Hudson reviewed in preparing his opinions, which meet the requirements of Hallmark, we believe this motion should be denied. Thank you.
Okay, thank you, sir. Mr. Neale.
Thank you, Your Honor. Your Honor, you've asked several times what to do with the dilemma about the missing data.
Yeah, that's what I want to know.
The first thing I commend to the court.
I tried to tee it up.
Yes, sir. And my answer to your question would be first to commend the court to a careful reading of Wilson versus Circus, where the Nevada Supreme Court says this routinely happens in foodborne illness cases. It's the norm. You will almost never have a surviving sample of the food in question. And so you never have direct evidence, or very rarely. And so you have to prove a case by circumstantial evidence. And what Wilson versus Circus makes very clear is that that dilemma doesn't change either the plaintiff's burden or the admissibility standards for expert testimony.
Now, here's my question, though, as far as the Circus case is concerned. Is that a Wilson versus Circus, is that a strict products liability?
I don't think it is, Your Honor. I think it's, and you've raised this point several times, Judge, that we are in a strict liability camp here. I do want to remind the court, there's also a negligence camp.
I understand.
Okay.
I do. But here, this is why I asked the question, because, negligence cases are a much different animal. We have to first establish a duty,
Sure.
then a breach. You know what it is. I'm not going to say anything else, but it's a different animal. That's all I'm trying to do.
It may be a different animal, Your Honor, but here's why the different species, if you will, doesn't matter. Because the causation requirement's the same in strict liability and in negligence. The plaintiff still has to prove proximate cause. And whether it's a breach of warranty, or negligence per se, or strict liability under any of the strict liability theories, causation doesn't change. And so,
Now, here's, I agree with that, but
Okay.
here's my.
we're making progress.
Yeah, we probably agree on a whole lot, but here's my point, and this is what I think has to be answered from a analysis perspective, because here we have a situation where we have a manufacturer of a product that's being put in the stream of commerce, right? And just as important too, we can go back to, I forget the case, but it'll be in the dealing specifically with the public policy in a site. I guess it's going back to, what was the first case? When he talked about Professor Prosser and the public policy for the reasons for strict products liability. And here's my, let me see here. I don't want to go through all this because it takes time. But anyway, it's kind of a different animal. And so we can agree on a couple of things in this respect. We have a product that was produced, right? And then once the production happens, there's potentially, and I'm saying this and I've tried to be very benign, maybe an unintended consequence, right?
Yes, sir.
And so normally when you, and when we talk about foodborne illnesses, which is typically more negligence-based, I understand what the potential burdens might be upon the plaintiff in that type of case. And they still rely upon maybe going down to Clark County Health District and things. They do an investigation and so on. It's been a long time. I handled a few of those way back in the day. But my point is this. Here we have a slightly different scenario where we have the manufacturing of a consumable good, right? And apparently there was and I'm going to try to be very benign in this respect, we had some potentially unique processes at play. Maybe that's what I'll call it, just trying, and what I'm focusing on there would be instead of doing a typical reverse osmosis, purifying of water, and maybe adding in a little salts or whatever Mr. Rasmussen was talking about, then you come up with your bottled water product. In lieu of that, they had this a different process involving the titanium rods, and it has some sort of impact. I get that. And I'll learn more about that process, but I'll call it a unique process. And so you have a unique process involved in the manufacturing. We can say that, I'm not saying it's good or bad, but it's something different, unique. And then we have potentially an unforeseen consequence as a result of that, and being benign once again. But it seems to me, unlike a kitchen, because in a kitchen, they're not testing for, it's not like a yeah, it's a different concept, right? And so when you have a product manufacturer, and I'm not throwing real water under the bus for this, for not doing testing for this specific item, but we know they didn't test for it, right? And so if they didn't test for it, and the plaintiffs weren't precluded from testing for it, just naturally, I'm not saying it was something that was nefarious or anything like that, just part of the way things happen, right? Why should the plaintiff be penalized for the inability to give an exact, you see where I'm going on that?
Yes, sir. And I want to again emphasize, Your Honor, we're not moving to exclude Dr. Hudson because he doesn't know how many micrograms per liter of hydrazine there are in a bottle of water. That is not the genesis of the motion. And it's not penalizing the plaintiff to enforce the standards of admissibility and the rules of evidence and standards for causation.
Well, but it depends. I'll tell you why. I think it depends. It depends on who you have control. And what I mean by that is, if that was the case, and if you flip it, and it's not the same, but it's kind of like the same. But when you talk about spoliation and those types of issues, right? I mean, because the plaintiff could have never conducted the testing.
Yes, sir. Can we set aside testing for 1 second?
Yeah.
We agree. Nobody can test the water that Richard Belsky and Keith Haley drink.
Right.
All right. So what Wilson versus Circus does is say that's hardly a unique circumstance. That happens all the time. What you have to do in a circumstance like that is prove your case through circumstantial evidence and with specific causation, medical causation testimony. And what the doctor has to do there is find circumstantial evidence that demonstrates the presence of a defect in a strict liability case and the fact that the defect caused the injury. And Wilson versus Circus illustrates two kinds of circumstantial evidence that an expert can use. One would be the latency period, and one would be common exposure. And what Wilson versus Circus says is that if a lot of people drink the same water or eat the same tartar sauce and only one gets sick, that's not dispositive, but it sure does tend to suggest that it ain't the tartar sauce. When we ask that question of Dr. Hudson, John, can you please pull up page 75 of his deposition?
But I thought he answered that on page 120 of the deposition. And this is what he said. I mean, it's looking here, nobody knows exactly the latency period, what the latency period is. It has all been hypothesized.
Yes, sir.
Now when you look at the drug-induced liver injuries in general, the latency period lies somewhere between 2 to 20 weeks.
No, I'm not talking about latency period right now.
Okay,
That's the
that's what I-
second one.
Okay.
The first would be common exposure.
Right.
And so for common exposure, he could slice it any way he wants to slice it.
And what page again?
Page 75, Your Honor, lines 3 through 8. He could do it by store and say, you know, Reno Whole Foods sold this and nobody else complained. He could do it by Washoe County Public Health Records. He could do it by the CDC MMWR, which did it nationwide and said, there's no injuries in the retail distribution area. But what he's got to do is he's got to do something to demonstrate why other people drinking this product don't have the same reaction he's ascribing to Mr. Halen and Mr. Belsky. And his answer to that is
What page are we on again? I want to make sure.
75, Your Honor,
Okay.
page 3 through 8. Excuse me, line 3 through 8.
I'm with you, I understand.
And then even more,
Wait, I'm on page 76, I'm sorry. I mean, the question is, do you believe some of the real water was safe to drink? Objection form, I don't know that. I don't know. Was any of it safe to drink? All I can say is not everyone got sick that drank real water, because there is thousands of people out there that drink real water. But we don't know what the dosage of or the amounts of hydrazine present in each of those.
okay, so he's saying there's a common exposure nationwide, and there's not a nationwide injury pattern. And when he's asked point blank, and I'll have to try to find this site, Your Honor, I don't have it at my fingertips. How do you explain that? His answer was, I don't have an answer for that. And John, maybe you could run a search for that while I'm addressing the other point with the judge. As to the latency period, Your Honor, you'll recall Mr. Belsky, his testimony that he stopped buying retail water when he got his first delivery of home delivery. That was well more than 20 weeks in advance of his hospitalization, which occurred May 24th, 2018. We have evidence of home delivery November 13th, 2017. So not only does Dr. Hudson not marshal circumstantial evidence to support his case as Wilson versus Circus says he has to, but he actually says, here's the latency period. And according to the plaintiff's own testimony, his last consumption is outside of it. It's the complete absence of not only the answers to those questions that Wilson versus Circus sets up, but even any curiosity by Dr. Hudson about them. He doesn't even bother. And when he said 20 weeks, I'll remind the court, that's not a latency period for hydrazine. That's a latency period for the longest known drug-induced liver injury causative agent. He has no idea where hydrazine fits in on the 2 to 20 week spectrum. But he does know, if he believes Mr. Belsky, that he stopped buying retail real water 6 months before he went to the hospital.
So when he's talking about latency period, he's focusing on ingestion. And in the general sense, I would anticipate he's basing it upon his experience as a medical doctor as it pertains to typically what the latency period might be for liver injuries. Is that basically what's going on?
Oh, but that's all we can guess, Your Honor.
Yeah.
He certainly doesn't cite a study or anything else.
But doesn't he have a right to do that?
He absolutely does, Your Honor. Again, let me make sure I'm doing a poor job explaining this to the court. If I'm an expert and I say that A caused B, then A must be within the latency period of B for my opinion to be internally consistent. What Dr. Hudson says is, A caused B, but my own opinion is that it's outside, or the facts put it outside of the latency period that I'm establishing. He sets up the latency period, falls outside of it, and isn't the least bit bothered by that. That's exactly what Wilson versus Circus says you can't do. And even if we ignore Wilson versus Circus, which I don't think the court can, then we've got to go to, the plaintiffs want you to go to Holcomb and be the first court that I'm aware of to adopt the mesothelioma standard for a foodborne illness case. But that just highlights Dr. Hudson's problems more, because under Holcomb, Your Honor, he's got to establish, he can't say that any exposure is sufficient. What he's got to say is that the exposure to that defendant's product was frequent enough, regular enough, and proximate enough to have caused his injuries. And that's why I want to say,
But doesn't he say that?
no, sir, he doesn't at all. What he says is, he drank both, therefore I assume it was both. Those are his words, not mine. That's page 74, line 25, to page 75, line 14. And let me ask you to look again, John. That's not it.
74, which line again?
Forgive me, Your Honor, that's not the right site. Let me try again. I'm sorry, it should be 119, Your Honor, lines 6 through 21, page 119, 6 through 21. And this is where he says, it's impossible to do what Holcomb requires me to do. I can't attribute cause to one exposure versus the other. So nobody in the world has the ability to parse out which dose or which product. In Mr. Belsky's case, he's got the name wrong, but Mr. Haley. Excuse me, he doesn't have the names on it, that's right. So this is his language at the top of the page there, on lines 6 through 8. Nobody in the world can tell you which one caused the damage. So you have to assume, since the water is the same, that it's both.
Because it used the same concentrate.
It used the same concentrate, Your Honor, but what you can't do is assume that any exposure at any period of time, no matter how distant in time, no matter how, I don't know what the opposite of proximate is, but no matter how infrequent, no matter how irregular, and no matter how not proximate, is equal. That's why Holcomb says you can't assume any exposure causes injury.
So what we're doing here is, we're not really, you said, okay, Judge, go read, what was the case again, Wilson, right? Versus Circus.
Yes, sir.
And you said, Judge, circumstantial evidence is fine. But then you come and say, well, really, we're going well beyond circumstantial evidence. Judge, you can't opine to specifics. That would be, I guess, a general medical causation burden. But it appears to me he's relying upon the totality of the circumstances and circumstantial evidence to come to his conclusion. Because it appears to me that what you're focusing on would be the specifics and not the circumstantial evidence. And am I missing something?
Yes, sir, you are. There's no circumstantial evidence underlying his assumption. None.
I mean, didn't we have individuals drink real water? They got sick?
Retail real water, no, sir.
Okay, well, I mean, didn't both plaintiffs testify that they consumed retail real water?
Haley and Belsky did, yes, sir.
Okay.
But again, let's go back to Wilson. That's the first admonition of Wilson,
Right.
is you may not assume causation from correlation.
But, I mean, but that's part of it. I mean, the first step of circumstantial, did they consume the product?
Your Honor, I agree that if they didn't consume it, they have no case.
Right.
But that's all that does.
Right, and they both suffered liver injury, right?
They both have liver injury, no doubt about that.
Right.
And it is impermissible to assume that it was caused by something without going through the Wilson versus Circus.
So which part of which tester is he, which component of Wilson, before I read it, so I can really focus on that he's missing?
Well, he's definitely missing the incubation period or latency period. He not only is missing that, he pitched to himself and swung and missed on it. He set up a latency period, and Mr. Belsky is outside of it. On the common exposure, I think he's got the same problem. Because he can't say that everybody who drank the retail real water, or any cohort, is sick. He flat out says, I have no answer for that. Those are the two circumstantial evidence supports, buttresses, that Wilson versus Circus identifies for a plaintiff. In Wilson, the plaintiff satisfied both of those. Here, Dr. Hudson doesn't even attempt to. He says, whatever the problem, whatever the threshold, whatever the necessary exposure is, I know he passed it because he got sick. That's not under Hallmark. I assume he got that, and that I assume the cause from that. That's exactly what Hallmark prevents. It says you can't do that based on assumptions. It has to be based on particularized facts, Sean. It's very akin to the biomechanic in Hallmark, who didn't know any of the variables of the automobile collision, but came in.
But I don't think that's why he was excluded. He wasn't a medical doctor.
Well, I think that's a big part of why he was excluded.
I mean, really, and that's why I've excluded every biomechanical that has ever testified in front of me when it comes to a motor vehicle accident, because they can't opine on medical causation.
I understand that, Your Honor.
Forces involved in an accident don't dictate whether a person is injured or not.
I'm not advocating a reversal of Hallmark, Your Honor.
No, I'm just saying.
But what Hallmark says is it has to be particularized facts, not assumptions. And this is it. Dr. Hudson goes so far as to say it'd be impossible to do what Holcomb requires me to do here.
And what does he say to that?
119, page 18.
I mean, I'm trying to figure out what you mean by that, because it appears he's pretty clear on latency periods, right?
Well, he's clear that Belsky's outside of it, if that's what you mean.
Or where does he say Belsky? Does he admit Belsky's outside of it in his?
No, Your Honor, he doesn't admit anything. All he says is the longest it could possibly be is 20 weeks. And then you'll recall, we went through the Belsky, I never bought retail real water after a home delivery. And we looked at his checks, and his delivery, and his contract, and it all backed up to 6 months before his hospitalization.
Didn't we have testimony from his mother?
We did. Let me address that.
We had testimony, but I mean, here's the thing about it is, it's not a question of addressing it. If we have testimony from his mother that's contrary, that's up to the jury to decide. I'm not gonna weigh and balance and say, well, his mother's wrong.
May I show you 2 clips, Your Honor, or not?
Yeah, but I can't, you're asking me to weigh and balance her testimony.
I'm not, Your Honor. This will. John, could you please play
I gotta go. Okay, thank you.
Belsky 94, the Belsky video clip at 94:10 to 95:6. And then you provided us and then when you got the home delivery, you stopped drinking, stopped buying the retail product. Correct. Did you ever, you must have occasionally bought bottled water after that.
Well, as I mentioned earlier, I occasionally bought distilled water for use in small home appliances, like a tea kettle, that type of thing. Sure, there would be times if I went to a gas station and I was thirsty, I might buy a Dasani or something like that. But
no retail real water purchases after that?
Not that I can recall.
Do you recall the last time you consumed retail real water?
I couldn't tell you an exact time. It would be in that time frame of some trip to Whole Foods just prior to the first delivery of the 5-gallon jug. and into that post-delivery period where there might have been some bottles still around the house.
All right, some bottles still around the house, and this is what Mr. Belsky himself says he did with those bottles still around the house, filled with 5-gallon water, please, John. I think it's page 41, line 22, to page 42, line 22.
When you started to have it delivered, did you continue to buy 1 to 2 bottles a week at Whole Foods, or did the quantity go down?
To my recollection, it stopped.
You stopped buying retail water?
Yes.
Okay. All right. Because you had a steady source of it?
As much as I could drink.
That means, I take it, that your mother never drank retail water that you purchased at Whole Foods?
Impossible for me to say. I had bottles that maybe were still in the house when I was in the hospital. It's impossible for me to say.
Where did you keep those bottles, sir? I'm sorry, let me back up. You're sure you had bottles, or you may have?
No, I'm sure I had bottles.
Whole bottles of real water?
Leading up to the point where I was being delivered real water by the 5-gallon jugs.
Right.
There were bottles in my house.
Okay. How about after that?
The bottles were still in the house, but they would have been filled from the 5-gallon dispenser.
Right.
Judge, your mother's testimony doesn't help Mr. Belsky at all by his own admission. It's not a common exposure to retail water. Ms. Belsky got sick, supposedly, drinking the 5-gallon water that was in his house.
Here's my question, though. Are you asking me to weigh and balance the evidence?
Your Honor, I'm not at all. By the plaintiff's own admission, he has no exposure to retail real water within Dr. Hudson's latency period.
Did he say that?
In those words, no, Your Honor. You have to put Dr. Hudson's 20-week latency period together with Mr. Belsky's sworn testimony. But that's the kind of thing that happens all the time as a matter of law.
Yeah, but no, I don't weigh and balance issues of fact as a matter of law.
I'll-
And did we ask the mother whether they were new bottles or old bottles or?
Your Honor, I think Mom was, she talked a lot about soft bottles and how she didn't like soft bottles and threw them out after a few uses. I think Mom's testimony is all over that.
But I mean, for example, Mom, when you saw the retail bottles, were they attached, cracked seal, any of those types of questions asked of them?
I don't,
It was, Your Honor, and Mr. Neale knows it was.
And my point is this, I don't have it right in front of me, but that would be the type of question I would ask as a practitioner if that was my defense.
Your Honor, and I think anyway, I'll set aside Mom and Mr. Belsky. I'm trying to convince the court of something it doesn't want to be convinced of.
No, it's not that. I just understand that if you ask, but if there's contrary, if Mom says, look, they were new bottles because I know I had to crack them open.
All right.
I can't weigh and balance. Wouldn't a jury decide whether that's within the latency period or not?
All right, Your Honor, I hope the court takes the same approach on, for example, plaintiff's motion for summary judgment, number 1 on the opening day.
Trust me this, it's almost kind of like, when it comes to summary judgment motions, this is what I look for in a general sense. I ran the red light. You know, I don't mind saying that. I have to go back and look, but I can tell you this, and
No, I'm sorry, Mr. Neale, can I just give one citation?
I'll have to go ahead, but I have to go.
All right. This is a part of our opposition.
They tell me I have to go somewhere.
Hey, Chris. Put our opposition on the board right quick. And I'm just doing this to, I think I see where Mr. Neal is going, but I thought this would bring an end to this conversation regarding Maria Belsky. This is our opposition, page 13, Your Honor. And this is line 11 in her deposition. She says, when I opened it the first time, it was sealed. Go up right there. It was sealed. Line 3, Maria Belsky. So I think that addresses the court's last comment, and certainly addresses what Mr. Neale was, I think, looking for.
Your Honor, I'll leave it at this, and I know the court's.
And sir, trust me on this. I'm sensitive to questions of law. That's the best I can say to you.
Very good.
Yeah.
Setting
And I
that,
think you know where I'm going.
I do.
I'm very sensitive to that.
setting that aside, Your Honor, we have Dr. Hudson himself saying, there are 2 defendants here and 2 exposures. Even if we give plaintiff the application of Holcomb, which I don't think we should, he still has an obligation to set out regular, frequent, and proximate exposure from a product attributable to each defendant. He has to say, if he's gonna say that retail water from UNFW caused an injury, he has to be able to attribute it to that product. And he can't assume it's both because it's the same water. He has to do an analysis of the regularity, the frequency, and the proximity of the consumption. That's the lesson.
And I just have one question for everyone in that regard, as far as exposure. Am I gonna be requested to accept that as the standard in this case?
Holcomb, absolutely not, Your Honor. Wilson is the standard, according to UNFW. I think the plaintiffs advocate for Holcomb.
Holcomb, Your Honor, again, is a strict liability case where Wilson is
Well, the
not.
only reason I'm asking that, because I wanna read them in more detail so I can apply. That's all.
And then, Your Honor, just because Mr. Neale mentioned this, again, Your Honor, we pointed to the court on page 118 of Dr. Hudson's testimony, where he specifically says, because Mr. Neale left off saying that Dr. Hudson said he was assuming, that's what he says, completely the opposite. No, I do not think we're guessing at all. I think since it's the same concentrate, it's the same water, it's the same bottle, so it's got to be both. This, all supposition is gone at that point. He gives an opinion to a reasonable degree of medical probability, and Your Honor, you hit the nail on the head. The position and the standard for these types of motions is you don't weigh the credibility of each witness in determining whether or not to grant this motion. That's for the jury to decide.
Mr. Odou.
Your Honor, I just have 2 quick points while we're on this topic of the standard. The first is, we've got a lot of discussion about that's a negligence case, that's a strict liability case.
Right.
Perhaps those 2 are different standards. I would point the court back to the Wet and Wild case, which is a negligence case, and it cites for the standard the strict liability Guinness case. So the Supreme Court has looked at both negligence cases and strict liability cases. And I just wanted the court to be aware of that.
But for what purpose though? I wanna make sure.
For the court, so in Wet and Wild, the negligence case, they cite the Guinness case and say that this court previously held that evidence of subsequent similar accidents involving the same conditions may be relevant on the issues of causation and whether there's a defective and dangerous condition. And that is,
I got you. I understand.
so that's the first point. The second point I would like to draw the court's attention to is we've been talking about the Holcomb standard. As the court's well aware, if the defense is going to offer alternative theories, it's the Masicato standard. Those are 2 very, very different standards. And that's why it would be unfair in this case to adopt a mesothelioma standard for the production of evidence by the plaintiffs and require the defense experts to say, to a reasonable degree of medical probability, this other cause happened. It's got to be the same standard for both, Your Honor. And right now, what we're looking at is arguments that there are 2 standards.
Yeah, they could, yeah, I understand what you're saying. I'm gonna have to decide.
Just wanted to bring that to your attention.
I do.
Thank you.
So, before we go, because I got a call, I have something I have to do, don't I?
Yes.
Yes. Mr. Neale, what was the case again? You wanted me to look at? as far as the-
Wilson versus Circus addresses the court's concern about the absence of the product to test.
As does Holcomb, Your Honor.
I'll read both.
One critical difference, and I will point out to the court that in Holcomb, medical causation was conceded. It wasn't even an issue.
I understand.
It's simply an exposure case.
I understand.
Yes, general causation in that asbestos can cause mesothelioma in some people, just like in this case, hydrazine can cause liver failure in some people.
Okay. I have to go. In fact, I'm probably late right now, and I don't know if I can come back this afternoon. Just want to tell everybody. It's one of those unforeseen circumstances.
No worries, Your Honor. No worries, Your Honor.
Would you like to have the next
check back
Friday?
with the court, or?
I would, from what I know now, there's probably a good probability I can.
Okay,
What I would do is this, but fortunately, we do have next Friday opened up for me.
that's it. So we'll be here next Friday, a week from today.
And we'll pick up all of the lost time Friday, because we weren't scheduled to go Friday, but now that's all done.
Sounds great, Sean.
Thank you, Your Honor, we'll see you next Friday.
Also, by then, I will have, without question, published a lot under advisement. Thank you, Ron.
All right.